My name is Rich Thompson. I have my own business called Capital Consulting, primarily doing lobbying at the State House. I represent the main trial lawyers. I've represented a number of businesses and companies over the last 12, 14 years. And before that, well, I practiced law for 25 years, and my primary client is the main trial lawyers now. I had the pleasure of representing your organization at the legislature on this issue, LD 1469, and it was a very positive experience for me dealing with clients that were very willing to do the work to speak to legislators, to contact legislators, to do the legwork type of things that need to be done to really gain success in Augusta. Too often I deal with, well, start with the basics. Too often I deal with lawyers who are like herding chickens, you know, to try to get a bunch of lawyers all pointed in the same direction is not always easy. So it was really a pleasure working with Michelle and everybody. So we were able to pull off what I think is a pretty remarkable feat in that we were facing opposition from obviously the national organizations that have been stepping in trying to control the market and have been very successful fighting in other states. And primarily, I think it would happen because your organization started their groundwork before I became involved and made contact with some very key legislators, explained the situation to them as well as you could in the sense of them understanding it, and had made a lot of inroads before I even became involved. My job then was to organize the hearing, to make sure we presented our position clearly, and then to negotiate the final outcome. We didn't get every single item we were looking for in the original bill, but with the help of several key legislators, we were able to do what is pretty amazing, and that is to get a unanimous report out of the Judiciary Committee on the bill, which then made it in essence, a relatively easy journey through the House and the Senate and the multiple votes, even though we negotiated with the other side, or some of the people from the other side during the process. There were others in the background sniping at this, even on what we were able to accomplish. So I'm going to go through the bill. I want to go through it all, and you can stop me and ask questions if I think we're getting interrupted too much that interrupts me being able to give you an overview. Then I'll just ask you to hold off on the questions. But if there's something basic that you don't understand, please, feel free to raise your hand, and we'll make sure you understand me as I'm going along and going through it. Some of it is going to be pretty basic, and so I'll start. It ends up being added to Title IV of the main statutes, and it starts with Section 771 under a new subchapter 4. And so it starts out with general provisions, and that is starts out with definitions. And it defines a court reporter, a court reporting service, a court reporting services provider, a governmental entity, and it defines a legal proceeding. So I won't go through all of them, but a court reporter is a person who records legal proceedings by steno machine or other means allowed under the main rules of civil procedure, Rule 30, and provides written transcripts of those proceedings. To simplify it, I'm not reading it exactly. A court reporting services means the services provided by a court reporter. So these are terms that are going to be used in the law at certain points. And a court reporting services provider is the companies, in essence, that you've been dealing with that have been creating a problem, to put it simply. Then we define government entity because they are treated differently in some aspects of the bill. They're not treated with the same. And we define a legal proceeding pretty broadly. I think it can cover just about everything you do. It is a court proceeding, a deposition, an administrative hearing, an arbitration hearing, any examination under oath, or a sworn statement. So I think that's broad enough to pretty much cover everything you do. So these ethical rules will apply to all of your work, and which is what we wanted to do. We wanted to make sure we didn't try not to leave anything out that should be covered by this. Section 772 is the next part of the law, and its relation, and the heading is relationship to party or proceeding prohibition. So this is pretty basic, and if you read this, it's self-explanatory. It says you can't be a court reporter for a proceeding in which you have a financial interest, in which you're related to one of the people. There's a family relationship, or if you're a family relationship to the lawyer. Anything that would be an appearance, an actual conflict of interest, or in essence, an appearance of conflict of interest. So those are the types of things that I think are pretty straightforward, and everyone will understand those exemptions. Section 773 starts to get into the important part of the bill and the statute. And this is, the heading is prohibited actions. And these are all things that a court reporter or court reporting services, these are all things they cannot do. They may not do. Each one of these would be an ethical violation. And I am going to go through these in some detail. They cannot enter into an oral or written agreement, and then it lists all of the people that they cannot do these things with: an attorney, a party to the action, an insurance company, third-party administrator, or any other person or entity that has a financial interest in the case, action, or legal proceeding, other than the contract that you enter into to provide court reporting services. So what they're saying is there can't be any hidden contracts in the background that ties you to one of the parties. You have to be independent and have no extra contractual relationships with any of the other parties to the lawsuit. So that, once again, everybody's treated fairly. There's no hidden agendas and all of that. Now, that doesn't stop a court reporting service from dealing with an insurance company and saying, we want your business to arrange for depositions and all of that. That does not, in essence, put them out of business. Senator Godding was our shepherded this through the legislature, but he had some conditions, and he said, I'm not looking to put these people totally out of business. I'm just looking to make what they do a fair playing field for everyone. And so when our bill had some provisions in it that would have been pretty draconian to the other side, and we fought to keep them in there to a certain point. And but when our people that are supporting us tell us, no, I can't live with that, then you do what you have to do to get a bill together. So did we get everything that we wanted? No, but I think we got a very substantial bill, and you'll see that. The next thing they may not do is give an economic or other advantage to a party or a party's attorney, et cetera, representative, agent, insurer, or employee, without offering that to all of the other parties. So if you're charging a $1.50 a page for a copy to one party, you have to charge $1.50 a page to the other party. And it's something that you will have control of, and we'll get into those aspects, which is very important in a minute. And you cannot enter into a contract to provide services on an outcome basis. I'll pay you if we win the case. I'll pay you double if we win the case. You know, that type of thing. You can't have a quote contingent type of fee with anyone. That's just a basic item that was put in here. The next one is restrict the choice of court reporter, and that is the services cannot enter an agreement for court reporting services that restricts an attorney from using the court reporter or court reporting service provider of the attorney's choosing. Now, this is a little tricky aspect to this because in a way it can be circumvented to the point where what we're saying is the provider hired by the insurance company in theory is not supposed to tell the lawyers you can only hire these people. Well, they'll, to put it bluntly, the attorneys are going to hire who they're told to hire. You know, if it's being paid for by the defense, by the insurance company, and the insurance company is using someone to obtain court reporters, that's really not going to be an issue. It's just the way it is. That really vision does realistically. Another one is you cannot enter a contract for court reporting services that allows an attorney at all to interfere with a court reporter's right to deal directly with all parties to a proceeding. Now, this is the key one, okay? And being a plaintiff's attorney, I'm going to use the defense attorneys as the bad guys, and the plaintiff's attorneys, just so that whenever I talk an example, we'll always understand who we're talking about, all right? So, you have been dealing with court reporting services, and they have been saying to you, we'll pay you to do the deposition. You send a transcript to us, we'll sell copies to the plaintiff. They can no longer do that. It is unethical for them to tell you that, for them to have that in their deal with you. It can't be waived. So if they contract with you, they can contract with you, obviously on your appearance. If they're holding the deposition, they can contract you on your appearance, on the cost of an original, and the cost of copies for them. That's what they're doing. That's what you would do in any deposition. You would make a deal with the court reporter to pay them on an agreed upon price. They do not then control the transcript for purposes of the other parties in the case. So if, using in a simple example, if there's only a plaintiff, that plaintiff can only buy that transcript from you. They do not buy it from this court reporting service that is contracting with you. They have the right to buy it from you at, in essence, the same price that you're charging for copies to any other party. So no more of overcharging one party to subsidize the cost to the other party. If you negotiate and in your normal rates, then you would, whatever your normal copy rates are, that's what you would charge the plaintiff's attorney for their copy of the deposition. You have the right to quote those at the deposition. If they ask you what your prices are, you have every right in the world to tell them out loud. No one can stop you from quoting your prices. No one can stop you from dealing with them, whether it's in the middle of the at the deposition table, or after the transcript's closed, obviously, but out in the hallway, whatever. They cannot prohibit you from talking to the other parties. So if there are 10 other parties you provide copies separately to each one of them. You have to treat them all fairly, but it's your control of that. Now, logistically and practically on how this is going to work, there are some, we were talking earlier, and there are some issues that I don't know the practical answer to. In the law, and we'll talk about that more, the fact that they have, no one has any authority to alter your transcript at all. Now, I'll make one, we'll talk in a minute about whose name goes at the bottom of pages and all that, but that's not really part of the official transcript. And I don't necessarily, we'll talk about that in a minute, but they cannot, if you provide them an electronic document and say, here's the original document, 64 pages, they cannot turn and reformat that and make it 75 pages, because you're going to be selling that, a copy of the official document, to other parties, and they have to be exactly the same. So I don't know how this dialogue is going to get opened up with them. They are no longer going to be able to make extra money by reformatting your work. And I think clearly what is going to have to happen is that you probably should be giving them some notice that when you send them, if they, for example, as they usually do, right, they want it electronically. You're going to say to them, here's the original transcript. It's 68 pages, which is the exact transcript I will be providing to the other party. You don't have to tell them they can't change it. If they do change it, they're in violation of the law. And the other party can go to the judge and say, Judge, I'm using the official transcript. They've handed in something to you that's not the official transcript. And the judge will then deal with that issue. So that was a key part of what we were doing, making sure that they aren't playing with it and all of that to make the transcript different than what you provided.
Can I ask you a question?
Sure.
I'm curious to know, these outfits are usually from away, as we say. Does the main law travel with this off to Milwaukee, you know, when it's with them? And
Yes,
realistically, I mean, so they've got it, they're in Milwaukee, and they start contacting people, perhaps we didn't, and they're doing all these other things. Do you understand my question?
There are enforcement provisions in here that we will get to.
Okay, but that transcript
Yes, it
is
applies to
governed
any-
by those laws,
It applies to
no matter where it
any
is.
deposition involving a main
Okay,
proceeding,
that's the answer.
in essence. Okay? And probably broader than that in the sense of if you're traveling to another jurisdiction with a court reporter. If they take a court reporter with them to New Hampshire, the same rules would apply because it's a main court proceeding. So, but I'll get into that a little more. This particular one of interfering, they cannot interfere with your right to do that, to control your own transcript. They will get the original and they can print it and all of that and have it available to file with the court if they intend to use it. But they cannot alter that transcript, and it's very clear in here. The next section has to do with comparable treatment of all the parties. And this is interesting. It spells out directly some of the things that were happening, I think. Itemized statement. At any time during or following a legal proceeding, whether it's during the legal proceeding while the lawsuit's going on or something happens and the lawsuit ends and then someone finds out I got ripped off or, you know, thinking they got ripped off or whatever. An attorney or party is entitled to an itemized statement of the rates and charges for all services that have been or will be provided by a court reporter or court reporting services provider that is providing court reporting services to any party to the legal proceeding. So if I say, why am I getting charged $2 a page? How much are you charging the other side for a copy? I know the price is different for an original, but how much you're charging the other side for copy. It has to be a comparable price, and you are authorized to tell them what you're charging the other side for a copy. They cannot tell you not to disclose that. The law says in this public policy that you are allowed, and in fact the other party has the right to make sure they are not being put in a position of paying more for the same product. The court reporters are required to provide the parties information on prices and terms and conditions so that they have a chance to talk to you about prices before it happens. Okay, so if you negotiate to do a deposition and the other opposing party calls you and says, what are the prices going to be for this deposition? They're entitled to that information and you have to provide it to them. And upon request, a court reporter or court reporting services provider shall provide an itemized interest of all rates and charges to the administrative body of the court or tribunal if they request it. If the court says, I want to know what's going on here, and they ask for all the information, they're entitled to that. It says, the provisions of this chapter cannot be waived. So they can't force you to, well, I'm not going to hire you unless you do it the old way. They can't do that. It's against the law. And the court has the authority to prohibit them from doing any court reporting services in the state of Maine if there's an egregious violation. They can kick them out of that case easily, prohibit them from being in that case, but they can also extend that prohibition. I don't think any court is going to extend that prohibition the first time there's an occurrence or a problem. Obviously, they're going to look at it and say to the parties, here's my remedy. Government entities are exempt from a number of these provisions. So the state of Maine can negotiate any type of deal they can get. That always happens in most all of this type of legislation. And nothing in this prohibits anyone from doing pro bono work. Charging someone nothing is not the same as giving them a better deal if it's pro bono based. The next is the remedies. Any party may file a motion alleging a violation of this subchapter with the administrative body, court, or administrative tribunal in which the action is based or is scheduled to be heard. It does not require a separate cause of action to have a complaint about this. So it's not like you have to create a whole new legal case or any type of thing like that. If it comes to one attorney's attention that they are not being treated fairly under the provisions of this law, they can file a motion with the court asking the court to review it, request the information. That's where the court would step in and request detailed pricing and all of that, and then the court has remedies. And the sanctions, in addition to any remedies that's already available by law, and those are the broad powers of a court to do most anything to any of the parties when they're in the middle of a lawsuit. Broad powers of control over the lawsuit, obviously have powers of contempt and all of those. In addition to that, anyone that receives such a motion and determined that a person violated the law can refuse to admit the contested transcript and bar the person from providing services in matters before that administrative body, court, or administrative tribunal. And that's broadly written so that it can be not just for that particular case, but on a broad base, that you're no longer can provide court reporting services to the Superior Court or something to that effect. The application of the law applies to court reporting services performed in this state, whether a party appears in person or by remote means. If it is provided by a court reporter, whether or not they're based in this state, okay, if it's a legal proceeding that's commenced and maintained in the state. So they cannot import court reporters and use and violate this law. There's no licensing for court reporters, so they can bring in out-of-state court reporters, obviously, but they can't use that as a way to circumvent the provisions of this law. They're still violations. And it also covers a court reporter or court reporting service provider based in this state in connection with a legal proceeding that is commenced or maintained in a foreign jurisdiction. So if you are a court reporter based in this state, these ethical rules would apply to you if you perform services out of state. So that allows us to hold outsiders applicable, making them applicable to the law, and we're saying we'll do it reciprocally, that where it also applies if you go out of state. So that is, I've gone through the statute of what's in there, and I think the one issue that we keep hearing and questions about is the control of the transcript. And to put it simply, you negotiate with whoever calls you to do a deposition. You negotiate with them for your price. But they cannot say to you, we are going to provide the copies to other parties. It's illegal for them to do that. And you have the right to talk to any party about your costs and provision of transcripts. And they cannot in any way inhibit that. So that's the basics.